Another common question that we've seen is for individuals who are on their immigration journey for a fiance visa or a spouse visa, they want to know what happens if I previously applied for a tourist visa and I was denied. A lot of people are worried about how that will impact their eligibility and their application. And that's a great question. That makes sense. So I just kind of want to break down exactly the difference between a tourist visa and then applying for a fiance visa or a spouse visa. The main difference, of course, is one of them, the tourist visa, is something that's short term, and then the fiance visa and spouse visa are something long term. And by long term, I mean your intent to live in the United States. Tourist visas are something called non-immigrant visas. That means the individual has non-immigrant intent, which is essentially a fancy way of saying that the immigrant doesn't have the intent of coming and living in the United States and making a life here. They have the intent to come to the United States for a limited purpose, which is to visit or to stay for a short time, but not to actually live here in the US. With the K1, with fiance visas and spouse visas, the intent is, and immigration knows that is the process, is that you're coming here to live and to start a life and have a life together. For a tourist visa application, there is something called discretion. Officers have discretion, which means they can make a decision about whether or not they believe that the immigrant has the right intent, whether or not the immigrant has the intent to just come and visit, or whether they have an intent to actually come here and stay here and live, which isn't allowed on a tourist visa. Tourist visas are generally very difficult to obtain, and a lot of times individuals will get a denial on the tourist visa if the officer believes that the person doesn't have the intent to leave the US after visiting. So depending on why your tourist visa application was denied will determine how that will impact your fiance visa or spouse visa application. If your tourist visa application was denied because the officer believed you only had that you had the intent to come and stay here and live, and that you didn't have enough ties to your country of origin, if it was denied because of that, then in general, you wouldn't necessarily have issues with your fiance visa or spouse visa application. You would have to disclose that information about the denial, but it wouldn't mean that you would necessarily be denied for a fiance visa or spouse visa. So one of our famous phrases as attorneys is, we like to say, it depends. And we say that because it really does depend. Every case is different. Every situation is different. And so it really will depend on why your tourist visa was denied as to what impact it will have on your fiance visa or spouse visa. So if you've had a tourist visa denied previously, don't panic. That doesn't mean that you're not going to be eligible for any immigration benefit. It's just going to matter as to why immigration denied your tourist visa. You'll have to disclose it on your application, and we highly recommend that you speak with an immigration attorney who can orient you, help you understand, okay, the tourist visa, whatever basis the tourist visa was denied on, and how that would impact your spouse or fiance visa. So it really does depend on why it was denied. If it was denied if you have prior immigration violations, if you had deportations or criminal history, yes, that denial of your tourist visa and those prior issues could impact your fiance visa or spouse visa application. So it depends, and it'll just be a matter of speaking with an immigration attorney to know how that denial would impact your case.